SJC-11582, Commonwealth v. Dwayne Moore.
Good morning, Ms. Anderson. You're probably not used to sitting on that side, are you?
Good morning, Your Honors. May it please the Court, Teresa Anderson on behalf of the Commonwealth. With me this morning, Assistant District Attorney Edmund Zabin, who is the trial prosecutor in this case, and I second sat him at that trial. There's two issues for this Court to decide and presented by this case today. First, we're looking at what does the phrase prohibited by law or court order in the revised Rules of Professional Conduct 3.5. And then second, I think this case presents an opportunity, if this court wants to take it, to revisit Fiddler. Certainly for the reasons set forth in the brief and that we'll make today, it's the Commonwealth's position that Fiddler remains good law and should stay as good law, and that this court should decline to revisit the case. First, there's no conflict between Fiddler and the revised rule. Fiddler is incorporated into the rule because Fiddler remains the law. I think that's the spectrum that we have as prohibited by law between the amicus, which says it's statutory criminal law only. We have the defendant's brief, which says it's statutory criminal law, in addition to the Massachusetts Guide to Evidence. And then our position being prohibited by law includes the common law, includes this court's decision.
But if we were to have done that, I mean, why would we do the revised 3.5 if we intended to keep Fiddler?
And this court may not intend to keep Fiddler, but until this court expressly overrules Fiddler, it remains the law. Prohibited by law is then incorporating the case law. Fiddler was both a common law rule and Fiddler was codified as a rule of professional conduct. When you change one, you don't necessarily change the other. Again, I understand this case might present the opportunity for the court to take a step away from Fiddler in the 1979 decision. Again, I don't think that that's the right step to take, but it could take that step. But as of today, until this court decides Commonwealth versus Dwayne Moore, Fiddler is the law in this Commonwealth.
Well, why wasn't the, quote, prohibited by law term in the rule just one aspect of Fiddler that referred to questioning jurors with respect to what actually went on inside deliberations, which has always been verboten?
And it has, and it's also verboten by other decisions of this court, Commonwealth versus Hieng, several years later.
It's also in 3.5 doesn't allow it either.
It doesn't expressly prohibit it.
But isn't that what was intended by the revised 3.5, that it was just referring to that portion of Fiddler?
I don't believe so, because again, it remains prohibited by law. And if that was the express prohibition this court wanted to take, it would have been incorporated in law. That's the amicus argument. The amicus argument is we can talk about jury deliberations. The amicus goes so far as to say, unless it's criminally prohibited by statute, which, again, setting aside that there are crimes codified by common law in the Commonwealth, unless it's criminally punishable with a statutory prohibition, it's permitted. And so inquiry into jury deliberations would be permitted. Again, looking at
But dear, there's a fundamental premise which I have trouble with, which is certainly the holding in Fiddler did not relate to the rule in Fiddler. I mean, there was a holding in Fiddler. That, of course, is not changed by the rule. But then Fiddler says, we announce this rule. And then that rule, which we had announced, was then codified. And then so why can't, if we announced it in a case and then codified it, why can't we not change it through codification?
Because it wasn't codified until 1991. Fiddler was decided in 1979 against the backdrop of a disciplinary rule that arguably allowed lawyers to contact jurors. It's an issue separate and apart from the common law. So for example, in Commonwealth versus Solis, Commonwealth versus Bresnahan, this court recognized that there could be Fiddler violations separate and apart from ethical violations. The rules of professional conduct are aimed at a different punishment, at a different subset of, they have a different underpinning and different purpose, setting aside from the common law. Again, I think that this court, if you're going to revisit Fiddler, both things needed to happen. First, the ethical rule needed to change, and it needed to go in this order. The ethical rule needed to change, and then second, this court can revisit its case law.
Didn't Fiddler involve two principles? One of them was an ethical rule, which essentially was a warning to lawyers to stay away from jurors unless the lawyer got unless the lawyer was approached by a juror, or unless the lawyer got the permission of the court to inquire of jurors under the supervision of the court. And then after that, there was a substantive provision of law that prohibited any inquiry into jury deliberations. And what the revised Rule 3.5 did was merely revise the ethical procedural rule that was announced in Fiddler. So you had a common law rule that has been superseded by a court rule, an ethical rule, and then the substantive rule remains unchanged.
I don't read Fiddler as two separate propositions. I read Fiddler as there is no lawyer-initiated contact of jurors, that to have inquiry into jurors, you need a showing of extraneous influence, and then it will be conducted in the court. And that is, again, principles that we should maintain, and specifically the judicial oversight is necessary, and I think this case is in point as why oversight is necessary. The ethical rule that was in place during Fiddler arguably allowed lawyers to contact jurors, so long as they did not harass, embarrass, or seek to influence future service. And so Fiddler then goes a step further, and Fiddler makes lawyer-initiated contact impermissible, prohibited by law. And again, Fiddler was the law. Fiddler is the law. Fiddler cannot be superseded by this court's rule change. Fiddler as common law. Again, today, this court can revisit Fiddler, and if we'd like to jump to that, we can.
Revisiting Fiddler in a case, I don't understand why we need to wait for a case to revisit a rule that we had established in a case.
Because the rule by its terms does not overrule Fiddler. The rule by its terms incorporates Fiddler.
And you would say Fiddler existed whether there had been no amendment to the rules of professional conduct post-Fiddler. The Fiddler rule would be the common law.
Fiddler was the rule between 1979 when it was decided and until it became the rule of professional conduct in 1991.
So if we, in the revised Rule 3.5, in your view, we could have said we are overruling so much of Fiddler as stated such and such.
Yes.
And henceforth, lawyers can contact. That would have been okay with you.
I'm not sure that this court can do that through a rule and through its rulemaking authority. I think it needs the case in controversy, but if this court otherwise using its powers to do so, perhaps it could. But it did not do that. Here, it specifically incorporated.
But wasn't it understood by everybody who was involved in that rule change process that that's exactly what we were doing?
No, it was not. And again, there's at least one group out there, I think it was the Mass BBA, that talked about we don't expect to see any changes coming soon because Fiddler remains the law. And certainly that was the district attorney's position, that Fiddler remains the law.
Position you never took.
Because I don't think we needed to.
We had to search for somebody to argue against Rule 3.5, and the AG volunteered
I guess
because
that's what-
nobody had opposed it.
But that's my point. I don't know that we oppose it. There is no opposition to adopting a model rule. It's a model rule that incorporates the current case law. And it's a model rule that can be adopted and expanded and modified going forward. For example, if this court wants to have a different rule for civil cases versus criminal cases, this court wants to have a different rule for some sort of innocuous contact about trial strategy, trial performance, that sort of, those sorts of inquiries versus here, where these very probing questions were asked of jurors that were relieved from their service years or later. And it's contrary to the remainder of the framework that we have to protect confidential juror information. I think it's important to note that this is a model rule. It is a one-size-fits-all, and it's been adopted in a lot of the jurisdictions. But going further than that, I think this court needs to make sure to look at where prohibited by law or court order has been interpreted in those other jurisdictions. Other jurisdictions have case law, have statutes, have local court rules, have procedural rules that that do not let this be a free-for-all. There is no...
For example, this is your point, I think, that you need some explicit announcement because the judge needs to be able to, or should be able to, say to jurors, you don't have to, give an instruction, whether you use the words that you're proposing or some other words, but give an affirmative instruction. You would say, yes, certainly that, particularly in a case like this, needs to be there, and people need to be on notice that judges need to, and parties need to be on notice that that's going to happen.
Absolutely going forward, and that's less of a concern than cases like this, in which when the jurors left, they were told that the lawyers cannot contact them. If they were
affirmatively told that?
I don't believe they were affirmatively told that, but they were talked about, but the discussion about the media and keeping deliberations to themselves. And if they received this letter and went online and looked at the juror handbook to see what their rights and responsibilities are, today the juror handbook says the lawyers cannot contact you. I think that's important to remember.
But that, of course, wasn't, that was correct at the time.
And I think, again, it's correct today, where...
So what do you want us to do? Do you want us to basically say Fiddler is good law, and when we say essentially it's okay to communicate with a juror, prospective juror, if to discharge unless prohibited by law, which it always is?
Correct.
But it's sort of silly for us to basically, essentially we would be undoing...
But I don't think that you changed.
3.5.
There was no change. Rule 3.5 incorporated the common law. Prohibited by law is prohibited as set forth in Fiddler.
You would say, I take it your fallback would be, okay, maybe that's not what you meant, but at the very least, you need to announce it, and so going forward, everybody's on the same page.
Absolutely. And so the rule change allowed for a case. Now it's this case.
So if we basically say, okay, we weren't clear enough, we really did mean to overrule Fiddler, you're content.
And here are the parameters. Again, I think that this court, there's a wide difference between we overrule Fiddler and it's a free-for-all, and taking these incremental steps in line with the rest of the framework in the Commonwealth. Juror information and addresses by statute are public. That's different from other jurisdictions. And so with that backdrop, I think we have to keep in mind when prescribing these rules as to when lawyers may initiate contact with jurors, if at all. And so I think that the small step that we would advocate that this court take is with judicial oversight and an opportunity to be heard, with no inquiry into jury deliberations, that an attorney without the showing of extraneous influence could ask for the court's permission to contact jurors in a specific way. Again, we've also gone through great pains and...
But that would essentially fundamentally change it, which right now does not require court approval. Right now, you can do it with court approval.
I disagree. Right now, you cannot do it without court approval at all.
Right now, you can't do it without court approval, and you're saying going forward, we should say Fiddler is no longer good law, but you still can't do it without court approval.
Correct. And the difference
So we haven't changed the court approval part.
Correct. But the standard being a showing of extraneous influence versus not a showing of extraneous influence. That would be the one piece that the Commonwealth would advocate taking out if this court were to make any change.
Could you, I just want to find it again. Can you point me to where the actual question, the letter that was sent is in the record?
In the Commonwealth's record appendix at page 60,
60, okay, thank you.
and I think the most fundamental problem with this letter is it requires and demands a response from the juror. It in no way informs the juror that they are under no obligation to respond. I think that is, again, the most disheartening and the biggest problem with this letter is these jurors, again, at their home are contacted by an agent of the defendant and asked basically, are you really sure? Were you able to follow the judge's instructions? And Judge Locke was conscientious, and particularly in this case, taking a jury from Worcester County, bringing them in every day, 9 days of jury selection. It's over 1,800 pages of the transcript.
Excuse me, how many letters, how many people received this letter?
I believe all the jurors.
And how many people have responded?
My brother's brief states that there are 4 responses.
So obviously they didn't feel like they had to respond.
I don't know. I don't know if they are.
Well,
Did
I
Judge
mean, they
Locke
didn't
put a
respond.
stop to this?
No, he did not.
He did not.
He sealed the responses. Any responses that are received are to be sealed. He declined the Commonwealth's request for a court officer to contact the jurors and let them know they are under no obligation to respond.
Okay, thank you.
Thank you, Your Honors.
May it please the court. Chauncey Wood for Mr. Moore. When this court adopted ABA Model Rule 3.5 and explicitly allowed lawyers to initiate unsupervised contact with discharged jurors as of July 1st, 2015, it necessarily overruled its prior holding to the contrary in Commonwealth v. Fiedler. Moreover, the rule applies to attorney conduct after July 1st, 2015, and therefore the date the jurors were discharged is irrelevant.
Do you know, Mr. Wood, whether or not the jurors in this case had been told that nobody can contact them about their service?
The answer is no.
You don't
to clarify, no, I'm sorry. They were not told that. What they were told, of course, is what every jury is told during the trial. Don't be put off if lawyers don't speak to you. They're instructed not to speak to you. I suppose there could be an inference from that. That standard jury trial instruction, the lawyers are not allowed to speak to you, please don't speak to the lawyers, that perhaps carries through beyond the trial. But there was, in fact, no instruction at the end of the trial, one way or the other, about jury contact.
But Ms. Anderson says, I haven't checked it myself, but the jury, what do you call it, handbook, the juror handbook says lawyers can't contact you. Is that?
I don't have any reason to disbelieve that. So if jurors read the jury handbook at that time, and I think actually today that the jury handbook
Right,
remains
that's what it
unchanged.
sounds like.
But with all due respect, this court, I think it's the most remarkable part of the Commonwealth's argument, and there are many remarkable parts, is that it's telling this court what this court has the power to do. It seems to me self-evident that this court, in its adoption of Rule 3.5, had the power to overrule its own prior rulings, including its ruling in Commonwealth v. Fiedler. That is the core of our position.
Well, we certainly have the power to do that. The question is, did we fully intend to do that when we enacted this new professional
Yes, and
responsibility?
I suppose that's a legitimate question. Now, I think that if this court, I highly recommend 2 things. The court,
What's the answer to that highly legitimate question?
the court clearly, as you can see from the entire rulemaking process, which was elaborate and extensive, included an oral argument, which is included in the transcript, included in the record appendix here, for the court's benefit. The court made clear what and the rules committee or the advisory committee made clear what the effect of the rule change would be, and this court adopted the rule. Chief Justice Gantz, at the very beginning of the oral argument, asked Dean Perlman, who was arguing in favor of the rule change, very simply, bluntly, clearly, how will this rule work? And Dean Perlman answered, this is all in the record appendix here, of course, that, for example, a lawyer will be able to stand out in the hall after the verdict and speak to the jurors. It was quite clear that there was a dramatic change in practice anticipated and in fact implemented by the adoption of the rule. Respectfully, as Judge Locke indicated in his brief memorandum of decision, it would have been completely inexplicable if the court had made no reference to Fiedler in its decision, but intended for Fiedler to continue as the law, where all of the record evidence, all of the reports from the advisory committee explaining how the rule would work indicated that lawyers would now be permitted to contact jurors.
Mr. Wood, would a lawyer reading this new rule want to exercise some caution in what he or she would do based on the change in the rule? In other words, are there any limits, as you see it, to what a lawyer can or can't do? If you say we implicitly overrule Fiedler, then Fiedler provided restraints, applied restraints, but now there are none. Is that the way this should work now?
Well, first of all, I disagree with the Commonwealth's assertion that this is a, quote, free-for-all, and I disagree with the implication that there are no restraints. First of all, it's clear in the rule's text itself that there are explicit restraints. We can argue about what prohibited by law means in a moment, and I think it does mean something, but beyond that, there's no harassment of jurors, the rule there.
Or misrepresentation.
Or coercion, there are 4 words. So I can give you the exact language, but it's in, let's see.
The communication involves misrepresentation, coercion, duress, or harassment.
Thank you. That's exactly what I'm
So
referring to.
are those the only limitations as far as you understand?
Well, the prohibited by law is a point that was not clear to me. And I think, and I highly recommend the court look carefully at the excellent brief from Macdel written by Foley-Hoag. They took a different view than I did. They took the view, the biggest question is jury deliberations. And I think Justice Spina gives an interpretation of Fiedler that's perfectly legitimate, that there's this second part of it, and that there is also in the case law, Commonwealth v. Hyang, most recently, a general prohibition, fairly read, on discussion of juror deliberations. Now, I think, first of all, if there's evidence of racial or ethnic bias in the jury room, that's arguably juror deliberations. But we could separate that out and say, okay, well, maybe you can ask questions about racial or ethnic bias, but not a pointed question, but not generally about juror deliberations. I think that there's support in the case law for that. I think, and more than that, it's clearly not admissible, any information about juror deliberations, not perhaps with the exception of, well, racial or ethnic bias, to the extent that's deliberations, would be admissible. So I took the view, consistent with at least one other state Supreme Court, that since I couldn't admit any evidence of deliberations, I wasn't going to ask about deliberations. So I took what I thought was a cautious approach. The Macdel brief argues, I think, reasonably, that it includes deliberations as well, for a lot of reasons. Most importantly, there's a textual argument that the old rule explicitly said you cannot talk about deliberations, and now the new rule takes out that limitation, so there's a reasonable statutory construction argument that now you can talk about deliberations. So I think that would be a reasonable argument. Beyond that, mistrials, the lawyer going, it's a different point than what we're talking about here, but a lawyer wants to go up to a juror after a mistrial, or frankly, even after just a verdict, and wants to say, how did I do? Professional advocacy sorts of reasons, development sorts of reasons. How did I do? What was effective? What was not effective? That's most useful, of course, in a mistrial situation. We're going to do this over again. What worked? What didn't work? That's very different, of course. And that, I think, gets into deliberations. And I think that's something that's...
That gets into deliberations?
I think that, well, I think it's not my case, but I think that the Macdel argument is, and there's lots of other courts that take this view, that a lawyer asking jurors after a mistrial, what worked, what didn't work. I could imagine that conversation could go something like, we thought this worked. There was a lot of discussion in the jury room about that argument about the conspiracy theory over here, or the eyewitness identification, or the scientific evidence. We thought that worked or didn't work. Some people thought it worked. Some people didn't think it worked. That, I assume, is the core of deliberations.
Do you know, Ms. Anderson made reference to this, and but I haven't done any research. In terms of the many states that have 3.5, but have adopted, in addition, court rules or guidance, in terms of this question about inquiring about into deliberations, do you know anything about what other is there a majority view in other states? Do you know?
Well, we extensively covered in our brief the other states. The headline I think that you need to take away is none of these other states that have adopted 3.5 in its current form prohibit unsupervised attorney contact of jurors post-discharge. And to the extent the Commonwealth is suggesting otherwise, it's important to recognize that's not true. That's the biggest point.
You mean
Beyond that,
prohibit all contact.
right.
Yeah.
Now, I off the top of my head, I don't think we specifically looked at it in terms of deliberations versus not deliberations. I don't know the answer to that. And of course, because I was taking the view, and I filed my brief before MacDill filed its brief, that deliberations were not what I was after, it wasn't, my view was, prohibited by law means deliberations. So I didn't spend any time focusing on
Is
that.
that on the other part of Fiddler?
No, I actually based it on Mass Guide to Evidence Rule 606B, because Mass Guide to Evidence Rule 606B very clearly states that deliberations shall not be admissible. I cited to I believe it was a Tennessee Supreme Court case, which essentially took the view that if something is not admissible, they also had the same Rule 3.5 and the same evidentiary rule equivalent of 606B. So they said, since deliberations are not admissible, lawyers should not be permitted to ask about them. So Massachusetts Association of Criminal Defense Lawyers cited a different case, Colorado, in which the court said, took a completely different view and said, you can ask about anything you want to ask about. Ask about deliberations, and just be aware that that's not admissible. Because Massachusetts has this case law that I think sensibly cautions or is explicitly states that jurors' deliberations are sacrosanct and that therefore inadmissible and lawyers should stay away from it, that Massachusetts could treat this differently. But I think that this court should address the serious argument made by MacDill on this point. Okay. All of this is irrelevant to my particular case, where I'm seeking something else entirely, extraneous influences and racial or ethnic bias, and actually I didn't ask about racial or ethnic bias,
yeah, if I can turn you to one point, the issue of whether it applies to trials before the date of the rule.
Yes.
There was one change we made from the ABA model rule, which is that the ABA model rule simply says the juror you may not, if the juror has made known to the lawyer a desire not to communicate. And we changed that to the juror has made known to the lawyer either directly or through communications with the judge or otherwise a desire not to communicate with the lawyer, which would give the judge the opportunity at trial to say, the lawyers may, if they wish, speak with you, but anybody who would prefer that they don't can tell me, and I will tell the lawyers they can't. The judge did not have the opportunity here to do that because the trial preceded this rule. So what do we do with that?
First of all, I think it's very, going forward, well, I know you want to talk about this case going backwards. Going forward, I am very resistant to a general instruction telling the jurors in any way that I want to know right now, make a decision about whether or not you want to be the lawyers to contact you. I am very concerned that would be perceived as coercive or in any event force a decision upon jurors prematurely. And at the moment of their verdict, it's the worst possible time to be asking that question. Give me a decision right now whether you want the lawyers to contact you.
Would you say it would be impermissible for the judge to do that with a rule?
It wouldn't be impermissible. Of course, this court, I say that perhaps too quickly. I think this court has the authority, not having thought about it terribly deeply, to indicate that judges can and indeed perhaps must give a specific instruction to the jury. I'm not saying the court doesn't have the power to do that. What I'm saying is, as a matter of policy, it would be a very bad idea because it would undermine the point of the rule, which is to encourage, lawyers to, or allow lawyers to investigate miscarriages of justice. So I think it would be bad to the extent you're at the very moment of your exhaustive deliberation has ended and you're perhaps ready to run for the doors, the judge says to you, oh, and by the way, do you want me to tell the lawyers that they can't talk to you anymore about this? Yeah, that's what I want. I think that is a very bad idea that would undermine the whole point of this rule change. Now, that's not the answer to your question. The answer to your question, going backwards, here, there was no opportunity. I think that the only way we can, the fairest way to deal with this is to acknowledge the point of this rule change. First of all, the rule applies to attorney conduct. I didn't make this argument. Mactel made this argument in its brief. I think this is by far the most compelling argument, that it applies to attorney conduct. And that conduct, as long as the conduct occurs after July 1st, 2015, it doesn't matter when the trial was. So the lawyers can do it. The fact that there wasn't an instruction to the jury, I think, is something that it's a balancing. And in this case, what we have to do is acknowledge that the rule was designed to uncover injustice. And I think therefore, we must, if we have to make a decision, the decision must err on the side of allowing lawyers to uncover injustice, because there's no way to bring these lawyers, the jurors back in.
But jurors are entitled to say, I'd prefer not to speak with you.
Of course they are.
So,
Yes, I think,
and we also have some jurors, especially after a murder trial of this type, which are traumatized by the experience and really want it to end with their verdict. And
Yes.
aren't their views to be respected?
their views are certainly to be respected in the sense that if they don't want to speak, they shouldn't be forced to speak.
Okay, so,
Absolutely.
and how is the
How do they
judge going
know
to
that?
communicate that? How are the judge is going to communicate that to them at the very end of a trial where you're basically saying you've returned your verdict, especially in a case highly publicized? Judges very often would give guidance to the jurors about what we'll do. If you wish to speak to the press, there's sometimes you say, if you wish to speak to the press, we will put the press in this room and you can go there so that the press are not going to bother you when you leave. There's a lot of stuff that judges do at the end of especially a highly publicized trial to protect the jurors who don't want to speak to anybody.
Well, I think you've raised, these are two separate questions. I think about the cases that have already been tried and going forward. Going forward, I think that the appropriate instruction should be short and sweet. I think the original instruction before Fiedler, which is in my brief, is good, but I think beyond that, perhaps a very brief statement. We have a rule that permits attorneys to contact jurors after their service is complete. You are free to speak to them or not. The choice is yours. I think that would be an appropriate instruction to give to the jurors.
Should it be included in a letter? In the letter from the attorney?
If this court going forward wants to make a rule that this should be a part of any written contact, I don't think that's unreasonable. I think that, and I need to make clear, I think Justice Hines asked this, made reference to this. In our letter, an exercise in caution, we actually sent our letter to the district attorney's office a week before we sent it. And the obvious point of doing that was to say, we're doing this. There's no guidance from the court. It seems to us clear that the rule allows us to do this. And by the way, it seemed clear to Judge Locke that the rule allowed us to do this. And if you've got a problem with it, you can do something about it. They waited until the day they contacted us at 7 o'clock at the night before. So that there was caution exercised here. But I think the contacting by a letter is also exercise of caution.
But going back to Chief Justice Gans's questions, so you give this instruction, the choice is up to you, and then, but how do we, or maybe we don't, is what you say. How do we kind of make operative the provision in Rule 3.5 about the juror has made known to the lawyer either directly or through communications with the judge or otherwise? So,
Sorry, do you mean for cases going backwards?
no, I'm talking about going forward.
Going forward, well, I guess if you're concerned, if you're saying that you want to make clear that jurors can convey to the court, you want to give them that mechanism, then what I would suggest is something like the New Hampshire rule, which I think is the most sensible thing. They say for 30 days, nobody can contact the jurors. I would alter that and say, if you would like the court, to tell the jurors, the lawyers, that they cannot contact you, I would ask you to wait 30 days, and then, if you still feel that way, to write to the court, contact the court. My point is, this is really important. The court recognized this in adopting the new rule, which is really a return to the old rule. This is incredibly important. This is a system that is flawed. It's a human system. Our system makes mistakes. You can talk about this in a lot of different ways, the number of exonerations by the Innocence Program. What I choose to say is, in the last 3 years, I could cite 3 big first-degree murder cases: Commonwealth v. Mark Shand, Commonwealth v. Angel Echevarria, and a rape case, actually, Commonwealth v. Ron John Cameron. All of these cases, defendants convicted of first-degree murder, rape. Conviction affirmed. After many years in prison, the court, new evidence came to light, and the convictions were reversed, and the Commonwealth dropped the charges. These are examples of what we all know now in a post-DNA world. This is a human system. It's a flawed system. And it's crucially important that we be able to uncover these injustices just as much in the cases that were tried before July 1st, 2015. There is no simple answer to Chief Justice Gantt's question, how do we contact the jurors in cases tried before July 1st, 2015? Really, the only choice there is to say, if you're going to say, since they weren't contacted before, they're off limits. That simply puts that entire 36 years of jury trials off limits for uncovering injustice. And I submit that would be that undermines the whole point of the rule. And I submit that, in fact, if you have to make a choice here, the choice needs to be allowing lawyers, perhaps in a letter, requiring lawyers going in these cases to write by letter and to make clear in the letter that you don't have to talk to me. If that's what you want to do, that's the best solution to allow for the lawyers to seek out injustice in these old cases.
So are you saying that it would be acceptable to limit the communication to written communications?
Well, I think that's an excellent question. I think that there's a problem that sometimes, first of all, there's issues of literacy. There's also issues of, I don't know. I'm hesitant to say that in every case, written communication is the only way that should be permitted. I think that it's probably fine. I guess what I would say is written communication, unless the defense makes a showing to the court that another form of communication is appropriate. Presumptively in writing, that it's okay that there should be a warning that the juror does not have to respond. But there are some instances in which another form of communication will be necessary, and it is something that should be taken up with the judge. I think that would be a sensible alternative as well.
All right, thank you.
Thank you very much for your time.